the further time goes out, witnesses are less likely to want to talk about it.
Right.
Hello and welcome to the Gartlan Injury Law Trials Podcast. I'm Aaron Gartlan, and the mission for us in any injury case is to ensure that we maximize the recovery and ensure that you receive the full value of your case. And that's the mission that we have here with this podcast, to bring you information and resources that are going to help you better understand the challenges that the injured face and what to do about it to ensure that you're getting the medical treatment that you need and receiving the full value, maximizing your recovery. For me, the thing that I've thought over the years that makes an excellent trial lawyer, Forrest, if you remember Randy Smith, he used to say, Aaron, we don't win our case at trial, we win our case at trial preparation. And Forrest, that's really, in my opinion, one of the many areas that you excel in. Today, we're going to be talking about a wrongful death case in the context of a very tragic automobile wreck. I really enjoy studying cases, reading cases, the nuances and the facts. I've always enjoyed that, even going back to law school. But something that I don't enjoy about the law is how harsh it can be at times, and the harsh reality of it, and the challenges in navigating families through that.
Right.
And I think that case, or this particular case, will really highlight some of the challenges that families face after a tragic automobile wreck, especially one unfortunately involving a death. I think it's literally a situation where ultimately there's no winners in that case. But this will also, I think, be a great opportunity to highlight some of your background and experience, because I understand this is actually, if not your first jury trial,
That's correct,
one of your first cases. Well, before we get into that, I wanted to ask you what you've been working on this week.
Well, last week we had a mediation. Last Friday it was in Montgomery, and I think several things will make that mediation memorable. But the biggest thing is that we're driving up there. It was in Montgomery, and there was snow on the ground. And so, which is very unusual for Southeast Alabama. But anyway, it was a mediation, and a mediation, as many people know, is a chance for the parties to get together with a neutral party and get the case resolved before court. And typically, mediations are a good thing. When I first started practicing, hardly anybody did mediations. I mean, it was just unheard of. And then as that concept grew, now we mediate almost in every case, and many times the judges require mediation. So we had the mediation, and then we are getting ready to file a lawsuit in a commercial case where an 18-wheeler hit our client, and we're trying to finalize that lawsuit, and we're going to get that filed hopefully today.
Just to touch on the mediation, I think one of the things that was really effective about that mediation, our mediator had a background, and you would think this would be counterintuitive, but a background in representing insurance companies.
Right.
So I think one of the effective, and didn't he say that he had mediated over 3,000?
3,000, yeah. And I've mediated with him many times over the years. And but even though he's mediated that many cases, he takes every case individually. And that's a hallmark of a good mediator, is that they spend the time to familiarize themselves with the case and sort of get a understanding of maybe where the case needs to land in a settlement, posture.
Maybe the conventional thought, or it would be easy to think that this is someone that most of his experience as a lawyer has been from the defense side.
Right.
In other words, representing companies, representing insurance companies. But from our perspective, we know that's someone that the insurance company
Right.
and their lawyer is going to value their
That's
opinion,
right.
value their evaluation. And I think that really helped in this case. And also the fact that our client was just a really good, hardworking
Right.
guy that just wanted to get back to work and get back to his
Right.
usual routine. Forrest, I'm excited to talk about your first jury trial. I think it really, again, highlights a lot of the challenges that families face after a tragic automobile wreck. I believe that's a good place to start. I know it's a automobile wreck that occurred over an op in Covington County.
Right. Well, actually, so I started law school in the fall of 1988, and the underlying wreck for this case happened in August of 1988. And the case, the style of the case, the name of the case is Garner versus Covington County in the city of Op. And let me just give you some of the background of the case. Sharon Davis and her mother, Ruth Owens, they were going to pick up Sharon's nephew and niece. The aunt and the grandmother lived in Laverne. They were going to drive to Op. Our clients lived just south of Op. And so, that was before cell phones. And they had arranged to meet, Sharon had arranged to meet her brother at a location north of Op, and they would follow them to their house. They arrive, pick up their nephew and niece, and they're on their way back to Luverne. Well, they're in the city of Op. They're approaching an intersection. And as they approached that intersection, they went through the intersection, and when they did, they were T-boned. Tragically, it killed Sharon's 19-month-old nephew. But fortunately for us, and fortunately for the case, there were many pictures. And so at this intersection, a stop sign faced our client, okay? But that stop sign was totally obscured by this large crepe myrtle, which just happened to have red blooms on it. The stop sign was almost totally obscured, and the driver of the car, Sharon Davis, the aunt, had never been through this intersection before. Now, she did go through it going to the family's house, but again, she had never been.
And stopped at that point because she could see.
That's right.
Could see the sign.
And so, but on the return trip, again, the pictures, you couldn't get around the pictures because it clearly, the crepe myrtle clearly obscured the stop sign.
So, Forrest, the initial thought of a family would be the city is responsible for maintaining, or some, whether it's the state, the county, the city, and it's a red crepe myrtle, it's covering the stop sign. Well, the responsible people are just going to step up, or the responsible entity, and compensate for the loss. So does it?
That was not the situation here, and there were a couple of things going on. The two primary defendants were the city of Op and Covington County. And let me tell you, you may be thinking, well, why is Covington County involved since this intersection was in the city of Op? We had gotten information through discovery that the city of Op actually had gotten Covington County to go out there and help maintain this intersection. So even though it was in the city, they had this arrangement with Covington County that they would come out and also help maintain this intersection. So that's why we had the two defendants. in the case. And the city took the position that the driver of the car, the aunt, should have known that there was a stop sign there because she had been through that intersection going the other way earlier that day.
On the way there.
But, on the opposing side, the stop sign was clearly visible.
Well, enforced in reading through the case, not only did they take that position, and this is one of the challenges that I want to impress upon people, an officer and writing the report, and I'm not blaming the officer here. I'm just talking about the harsh reality.
Right.
In the report, there was a statement that she had said, "Hey, when I on the way back, they used a witness testimony that she slowed down."
Right. That's right.
And also that she had made a statement to the officer. I immediately felt like I'd ran up on impact.
Right.
My immediate thought was, I've run a stop sign.
Right. And that's a very good point, because most drivers, when they approach an intersection, you naturally slow down. And that's what she did. And her first reaction, like trying to explain it after the wreck, was, I must have ran the stop sign. But the advantage that we had was that we had so many photographs of that stop sign, with it being covered with a crepe myrtle. And we were really lucky to have those photographs, because many times, in this case, they didn't hire an attorney till sometime later, and we were just lucky.
That wasn't their first thought.
That's right. That wasn't their first thought. Now, and the other thing that made this, that we were lucky in having these photographs going.
But Forrest, what you're saying, I mean, I think, and again, I'm sorry to interrupt there, but I think it brings up another challenge. It's not your first thought after a tragedy.
That's right.
Your first thought is, we've got to heal. We've got to let some time pass.
That's right.
We and
you can imagine there's a 19-month-old child.
But from what I understand, there was a witness, and I think their thought was, wow, this is a really bad wreck. And this poor family, she couldn't see the
right.
Nobody would have known. So and this is, again, not in the days of the iPhone or the smartphone. So they took it on themselves, which is very unusual.
Right.
You typically don't have, people generally don't want to get involved when things like this occur. So it's almost like a small miracle that somebody took a picture.
That's exactly right.
Because
we were very fortunate.
Otherwise, without witness testimony, that shortly after that, the crepe myrtle.
That's exactly, yeah. They were out there very quickly to cut that crepe myrtle down, because it was just so apparent. The danger was so apparent when you realize that there's a stop sign behind that crepe myrtle.
This is a case you actually had to file a lawsuit. It wasn't one that they reached out and said, "Hey, what can we do to help make this right?"
So a lawsuit was filed, and actually I passed the bar during this period while the case was being litigated, and then entered an appearance in the case. And we went through discovery, taking depositions, and the first deposition I'd ever been to was in this case.
Wow.
And
and were you taking the deposition?
It was a witness, and it was actually an employee of Covington County.
Okay.
And so it was finding out, what the county had done at this intersection.
Yes, because what you're trying to prove there, the city is responsible for maintaining it.
Right.
But there's also a case law that centers around. So the law is that the city is presumed to be responsible, or is responsible for the maintenance. But doesn't it also hinge on if another entity maintains control? Mm-hmm. So in other words, it maybe if the city was contracting with a private company for maintenance or if the county has control.
That's exactly right. So,
but it's not enough just for the county to be out there doing work on the section or supporting.
right,
It's, I guess, somewhat similar to independent contractor employee.
right,
It's different, but it's I think a similar analogy. Who maintains control? So you were the part of the lawsuit was to attempt to prove that Covington County not only did work to it, but that would be a way to show that they actually maintain control.
That's
of
right.
of the maintenance and the upkeep
That's
of the
right.
intersection.
So yes, so at trial we were able to get an affirmative jury charge. So the judge told the jury that the city of Up had a legal duty to maintain this intersection. And we didn't get the same type of affirmative charge with Covington County. Exactly for the reasons that you pointed out, is that the city has a legal obligation to maintain this intersection. And so we were able to get an affirmative charge that the city had, it was their responsibility. And then with Covington County, the jury was asked, do they control this intersection? Did they have control over it? And had they assumed the duty to maintain this intersection?
And the evidence was ultimately that Covington County did not maintain control. They were assisting from time to time at the request of the city. And what we're talking about is a burden of proof, the things you have to prove, the elements, the evidence that you had to show in this case to be able to, for lack of a better way to put it, to win. But the evidence in the case was ultimately that Covington County was assisting but not maintaining control. They were doing things from time to time at the request of OP, and there was no proof that they knew about the crepe myrtle covering the stop sign.
That's
so.
Right.
So our responsibility fell to OP.
Exactly. And so our burden to prove the case against Covington County was much harder.
Yeah.
Because, again, it was within the city limits of OP, and, they have the legal duty. So you're right. It was we had a much higher burden with the Covington County.
Because again, not to belabor this, but I think it's important for people to see the challenges here. The city, the law is they have a duty.
Right.
With the county, you had to show your
notice, control, things like that.
Yes. Right. You had to prove that they had taken on the duty.
Covington County tried to get out of the case, saying, this is not our intersection. We don't need to be involved in this case. And the judge ruled in our favor, saying, well, this is a jury question.
Yes.
I cannot rule as a matter of law that you're not responsible. I'm going to put this to the jury. To me, an interesting thing about the practice of law since I've started is the change in technology. And we were arguing motions, and the attorney for the city of Op, it was just an old Southern gentleman, and we were arguing, and something came up on a collateral issue. And so we were over and up arguing this motion. And, our office is in Dothan, it's probably an hour and 30 minutes away or something like that. The topic that we were arguing on, I had a case sitting on my desk in Dothan that was right on point. And I mentioned that to the judge, and I said, there's this case. And then we didn't have access to computers where we could pull it. And I said, Judge, I can get my office to fax it to the defense attorney's office, and that way we can have it. And the defense attorney jumped up and said, I'm not some big fancy Dothan law firm with fax machines, And so back then, a lot of firms didn't even have fax machines. And the other thing that has changed a lot is, we were making exhibits, having to blow up exhibits and things like that. So everything, instead of being on a screen, we had hard copies. We'd blow up photographs. And so, and I think it's been a good thing is that the technology has allowed us to better present our cases to juries, with videos and computers, monitors. I think it's easier for a jury to understand, the case. And, but again, it's just sort of interesting. Again, that was my first case and how technology's changed, because then fax machines were not even a big thing then. And
it really is unbelievable.
Right. So let me just tell you how the case progressed. We tried the case in front of a jury, and we represented the mother of the child, the deceased child, Gina Garner. The jury returned a verdict in our favor for $750,000, and which was quite a bit of money. Back in, I think we tried the case in 93 or 94, somewhere in there.
I think it actually, so like you pointed out earlier in reading through it, the wreck happened in 1988. I think the case actually went to trial, which this is something else that's a challenge. I think the case actually went to trial in 1990 and then made its way to the Supreme Court in 93.
Right, that's right.
So the time it takes to litigate a case, and that hasn't gotten shorter, it's now taken longer.
Right. So, we're still trying to catch up from COVID, where the courts were shut down for a long time. And, but you're right. I mean, that is it. And especially, when you have multiple defendants, things like that. And we had multiple plaintiffs in that case. So yeah, it does take a while. And, a lot of times you're at the mercy of the court when they're going to set your case for trial. But we were successful. We got a $750,000 verdict against the city of Opp. The jury found that Covington County, either they didn't have notice of this condition and did not have the control necessary to hold them responsible. So the jury found in our favor against the city of Opp. Now, one thing to keep in mind is we got a $750,000 verdict, but there's a cap for municipalities of $100,000. So the judge, following the jury trial, the judge lowered the verdict to the cap of $100,000. And we appealed the case. We said that the cap was unconstitutional. And our basis for that appeal, there was a provision. Then we were under the 1901 Alabama Constitution, and there was a provision that said the right to a jury trial shall remain inviolate, meaning that whatever rights you had to a jury trial at that time could not be changed, through legislation or anything like that. And also there was a provision in the Constitution that said municipalities can sue and be sued.
Yeah.
All right. So we argued that at the time that the Constitution was drafted in 1901, that there were no caps, and your right to a jury trial applied against municipalities just like it would an individual.
Yes.
And we argued that the cap was unconstitutional. Now, we had oral arguments before the Alabama Supreme Court, and the Alabama Supreme Court upheld the cap. And so, which greatly limited our recovery, to the $100,000. So it was a very interesting experience for me, because I got involved in the case before the trial started, and then all the way through the appellate process. So very quickly in my legal career, I got to experience not only a jury trial, but also an appeal.
In a wrongful death, automobile wreck. And again, to experience the challenge that a family faces, because contrary to what we see and hear so often, the last thing our clients want to do typically is go through, this tragic wreck happened in 1988. The Supreme Court affirms the jury verdict,
Right.
at least to the responsibility.
Right.
They affirm the jury verdict, holding the city responsible, and the legislature's ability to
Regulate
cap.
that. That's right.
And unfortunately, it's 2025,
Right.
and that cap is still the same. But my initial point was that that's 88 to 93, 5 years of litigation.
Right.
And them carrying the weight of having to prove their case.
Right. Well, the other thing that I think we represented the family of the deceased child. Another attorney represented the aunt who was badly injured in the wreck.
And was it the uncle also, or was it just the
It was the aunt and the grandmother who were the other co-plaintiffs.
Yes. And one received $100,000. I think the other one may have received somewhere in a range of 40.
Right. That's right. So I think, and I really didn't understand this, or I didn't appreciate it, the guilt that aunt had on her.
Yes.
For her nephew being killed.
Yes.
I think she did, even though it took a long time, and we didn't represent her, although we worked closely with her attorney. Again, we represented the family of the deceased child, the mother. I think she did get closure because, a jury vindicated her, saying it was not your fault. It was, the fact that the stop sign was completely obscured. And I don't think I ever realized, just in an automobile wreck, even though this one was extremely tragic, just some of the emotions that are involved. And like you mentioned, this was a long ordeal. But again, especially for our clients and their family, they got closure by, saying, it was not the aunt's fault. And so it was, that was a perspective that I just was not, familiar with in doing this, in starting my PI practice.
Well, in force, it's almost too like to add insult to injury. The witness that saw the wreck, that again took it on themselves to either go get a camera or they had a camera in their vehicle to get out and take pictures. That just doesn't always happen.
Right.
So that shows you that the witness felt like, hey,
that there has been an injustice.
Yes.
Right.
And for this family, not only is she carrying that guilt around, but the city's attempting to show, hey, you went through it. You stopped on the way.
Exactly.
And you slowed down. I think they used that same witness to testify. Well, yes, she did slow down. And then, when you're kind of recovering from all this, the statement that you make, like as soon as the first thing I thought on impact was, and that would be a natural thought, but that doesn't mean that you knew, and the fact that you went through there, you're still unfamiliar with it. So this is not an easy, I guess, one of the points I wanted to make earlier, I don't know that it did the best job. The natural thought for a family after a tragedy, and I think it's just one of the takeaways of this program, is we've got to heal. We've got to recover.
Right.
We're not thinking about that right now.
Right.
In our experience, the further time goes out, witnesses are less likely to want to talk about it.
Right.
Because if you wait 6 months to a year, oftentimes, and it's a natural thing, they don't want to talk to you because they've already had 5 other insurance company representatives or corporate representatives or city or whatever the case may be. They've already been. So oftentimes witnesses are less likely to want to get involved. And I know this is a long drawn out way of saying, what would your recommendation? Would it be to wait, or?
I think if you've been in a serious wreck, you need to contact an attorney as soon as possible, because, as you mentioned, memories fade, evidence disappears. And I'll tell you that the thing that we found in a lot of cases now is we can find video of the wreck, because there are so many businesses with videos. We'll send an investigator to see if we can find, the actual footage. And again, that shows you the difference in technology, from 1988 to the present.
Yes.
Is now it's hard to be in a place without a camera. And I'll give you an example in a case that we're handling now. Is we had a client who was on a 2-lane road, turned on his blinker, came to complete stop, waiting to make a left turn. And there was a lot of traffic coming in the opposite direction. So he's there for quite a long time, and a truck coming from behind him never hits the brakes, slams into him, pushes him in the traffic coming the other way. He gets hit again. Well, we sent our investigator out to some businesses around there, and he was able to locate a business that actually their security camera had footage of the accident. But getting back to your question, I would encourage people, again, if you've been in a serious accident, to contact an attorney as soon as possible, and at least get a recommendation or an idea of what your legal rights are and what you need to do to preserve those rights. And again, the most important thing is, especially if there's a dispute over liability, something like that, gather that evidence. The other thing is, many cars now have data recorders. And if your car is totaled and it's sent off to a salvage yard, you're going to lose the ability to get that data. And what we do is we've got a team of experts that will call in to download the data. And again, none of this was available in 1988. But so those are some reasons why I would encourage people to contact an attorney early on.
Well, and Forrest, to kind of follow up on that, the ability to get the camera, the business camera
Right.
footage that you refer to, that's if you can get it in time.
That's right.
So it's often
Exactly.
there, but they have no obligation to hold on to it. And despite some kind of order or subpoena, if there's a defect with the vehicle or some other issue that caused the wreck, if that vehicle's destroyed, the ability to inspect the vehicles that are involved or whatever the case may be, you're gonna lose that ability, because a company, a business, can legally at times basically destroy the evidence.
Right. And a lot of
once
times
it's gone,
and a lot of times the cameras may ride over them. So, with the storage, maybe it's every 30 days, a week, or whatever. But so those are reasons why, I would encourage somebody, again, if you've been in a severe accident, to contact an attorney as soon as possible. So getting back to the Garner case, and this probably won't mean a whole lot to non-lawyers, but when I went to the deposition, never been to a deposition before. And I sort of knew, I'd read depositions, and I knew it sort of what was going to take place. But I get to the deposition, and again, we've got this Southern attorney from Opp who's defending the city of Opp. We get in the deposition, and he objects to about every question. He says, "I object to the form of the question." And I had no idea what that meant. I go back to the office, and I said, he was objecting to the form of the question. And it was the form, but it was a Southern accent that, but again, even I wasn't sure even what objecting to the form was. But it's funny how, you look back, and I've probably been in 10,000 depositions since then. And, but that was, that one will always stick out to me, my first deposition.
Oh yeah, I could imagine. Like you said, for the listeners that aren't attorneys, basically the objective forum isn't that kind of a catch-all thing that basically means if a question's out of bounds,
well,
and
or
leave the judge to rule on it,
or it could be a compound question, or something like that, or it's not clear. A lot of the old attorneys would object to the form to every question.
Yes.
And it's not, I don't see that practice as much, but it was almost every question, when I first started practicing, the attorney would object to the form to every question. And you don't see that as much now. But again, it's just saying there's something wrong with the question that you ask.
And we may need the judge to rule on it at a later time.
Right.
Should the case go to trial or an issue come up.
That's right.
And if you don't put that objection, then you may not have the ability to bring it up later. Now, as we get closer to the end today, is there any other takeaways or anything that I didn't ask you about with the Garner case, or anything else you want to elaborate?
When we got to oral argument at the Alabama Supreme Court, I guess I just wasn't prepared for the attention that this case had gotten, because we had...
I'm glad you brought that up.
Yeah.
They want to hold on to that cab.
They wanted to hold on to that cab. So we had several associations, like the League of Municipalities, intervened in the appeal. They filed something called amicus briefs, Friends of the Court briefs, arguing, for the cap. But the courtroom, the appellate courtroom was full, of people because of the interest in this case. And, again, the Supreme Court upheld the cap, but it was, again, sort of a shock to me. We get up there, and then it is a courtroom full of people. And I've done many appeals since then, and a lot of times the only people that are interested in the appellate decision are the litigants involved. Now, it may have ramifications past those litigants, but you're not going to have people coming to oral argument to hear about it. But that was, again, starting out my legal career, doing a wrongful death case, and then having it, going all the way to the Alabama Supreme Court, was just to me, a very fascinating way to start your legal career.
Yeah, it's a great experience. In automobile wreck cases, just a few things that we kind of get down to the end of things that I think apply to everybody. We've talked about some challenges that would apply to a family that would find themselves in this very difficult, challenging situation. The most important thing is to get the medical treatment and the care that you need. And like you pointed out also, it's unfortunate, but it's just the reality. You're going to be better off contacting an attorney that you trust as soon as possible. Force, as you know, this is the part of the program that we like to give some advice, some takeaways. What can we learn, and what are the takeaways from our conversation, from the case we went over today?
I guess a couple of things that I would recommend. The first thing is that I always encourage people to go look at their automobile insurance, okay? And that's important to make sure that you're adequately covered. We have, and it seems like we're seeing this more and more, where people are hit in bad wrecks, and maybe the other party leaves the scene of the accident, has no insurance. So I would encourage people to look at their insurance policy and make sure that they have something called uninsured or underinsured motorist coverage. And what that does is, you can think of it as you have bought a policy of insurance for someone that hit you. And a lot of times that's the only insurance that's available. So that's one thing is I would look at your automobile insurance. And, I know people want to save money when you're buying insurance. And believe me, I hate to write that check to the insurance company paying those premiums. But again, I have seen so many situations where people have been horribly injured and there's just no insurance or there's very little insurance. And to me, it's worth that little bit more cost to make sure that I'm covered and that my family's covered in case of a tragic situation like an automobile wreck. The other thing that I would encourage, and again, if you're in a serious accident, I would encourage you to talk with an attorney after the accident, and I would do so promptly. Many attorneys, again, like us, personal injury attorneys, will not charge for the initial consultation. And the advantage of doing that is then you're armed with the information. You may not want to pursue a claim. You may not, but at least you've got the information that you can make a reasonable judgment. Should I pursue this claim? What are my avenues of recovery? Do I have to use the body shop that the insurance company picked out? Things like that. And so I think, again, I would encourage people to get legal advice so they do know what their legal rights are. So those are two things I think that our listeners should keep in mind is make sure you've got adequate insurance because, again, we see so many people without insurance or very minimal insurance. And, again, talk with an attorney. Many times it's not going to cost you anything to talk with the attorney. And with us, there's no obligation. You come to us, we'll tell you what your rights are, and you're under no obligation to hire us. So it does not hurt to talk with an attorney.
Yeah, and to take it a step further with that, Forrest, wouldn't you say not only are they under no obligation to hire us, we're going to give them our assessment if they even need to hire us.
That's
because we only want to take cases that we can help put them in a better position than they could achieve on their own. And typically that's going to be, like you've pointed out, those serious accidents, those serious injuries where, you're looking at the possibility of litigation, trying to determine how to pay your medical bills, your lost wages, all of those difficult challenges that families face. Those are typically the cases that we can add the most value, that we can definitively tell a person, you're going to be over your head with this.
But, and there's a lot of people that we see that, we tell them, look, there's no reason for you to pay us.
Yes.
Okay. You can it's property damage, minimal injuries or something like that. You can handle it yourself. If you have a problem, give us a call back. And we tell that to a lot of people, we arm them with the information where they can go out and, handle their case, because it's either a very minor accident, no one was injured, things like that, or let them know what to expect from the insurance company.
I've really enjoyed this conversation today, and I appreciate you and your friendship and the work that you do for our clients, and look forward to continuing these conversations in future episodes. Again, like you just pointed out, to arm people with the information and the resources to make the best decision for them and their families.
Right.
For us, I would say that a great case helps a family pick up the pieces after an accident or an injury, providing compensation for and ensuring the best medical care and medical treatment, providing for lost wages and earnings, and again, helping a family just pick up the pieces and get back on track. But the best cases actually touch lives and change policies, expose unnecessary risk and danger, and those that would place a greater value on profit and productivity at the expense of safety and human life. It means so much for us to be part of those types of cases. So bringing it back to the podcast or to this program, we want to provide people with the information, the resources to make that difference in their lives and ultimately back to our community.
Aaron, I really appreciate the opportunity to be here today and in telling the viewers about what their rights are. And I think this podcast, we hope to accomplish several things. One is, as we talk about some memorable cases that we've had, and we think that's useful. It helps people understand the legal process. We like to educate people on the legal process. We also like to educate people on what their rights are after an accident. And I think some things that go into making a good personal injury attorney is, and I know from my experience and your experience, we establish a bond with a client. And a lot of times, clients will call us years after their cases just to tell us, their children are growing up, they keep us involved in their life. And I think that human aspect and that connection is really what is necessary and what you would like to look for in an attorney. And so we would encourage anyone, if you have any questions, go to our website. We're available and we're always here to help you. And we look forward to our next podcast.
We really appreciate you watching and listening. Please make sure you subscribe to the program. Stay in touch with us. Check out our website. If you have questions or concerns, feel free to reach out to us.